Welcome to the second episode of the second series of The X-Files, the divorce and separation podcast with me, Alex, and
Hello, everyone. I'm Liza, and we're here to talk all things family law.
today in particular, we're going to have another look at property settlements in family law. The last time we did an episode was some time back, and there have been a few tweaks and changes in the law, and we think it's very helpful just to give a bit of a recap as to what's involved when running a property settlement case, or if you're sorting it out for yourself. But first off, I've got to do the disclaimer because we're both lawyers. This is just information. This is Alex and Liza having a chat about property settlements. If you need legal help, reach out to us and we'll be able to help you. Or if you have your own lawyer, please go and see them. Get tailored advice. Do not rely upon things that you find across the internet. However wonderful podcasts might be, they are just sources of information, okay? So, all of that disclaimer out of the way. Today, how property settlement actually works in Australia.
One of the things I really wanted to get across was in terms of property settlements, for anyone who thinks that, it's just going to be 50-50 anyway, that's not going to happen. That doesn't always happen. It's a myth. Divorce does not mean automatically 50-50 property settlements. That sort of thought process can end up costing you many thousands of dollars if you don't get that advice early on. So that's why it's super important. Stay tuned. Don't think, we've listened to this one, we're going to turn off now. There's going to be some changes in this episode. So let's get started.
It's, as an old law professor of mine used to say, the law is simple, but it's not easy. And I think it's a bit like that with property settlements because there's a lot of assumptions out there about, well, I get this share because my friend got this share or I read it on Google or Facebook or somewhere. We've got to start from the premise of, well, what do we mean by property? So let's break this down into, property, what does that mean? And then what processes does the law apply to decide upon when a couple have separated? So first things first then, when we talk about property in our family law context, Liza, what do we mean?
Okay, so we're talking about all the assets, whether it's in your name, the other person's name, liabilities, financial resources, including things like super, any trusts, interest in companies, things like that. The very first step is we write down everything that you've got in your name, everything that you've got in your spouse's name, and everything that you've got jointly with other people. You might have a share in a property with your mother-in-law, for example.
Wouldn't that be joyous? No, my mother-in-law's lovely. We don't really stay together.
I'm guessing that your mother-in-law is not listening to this, Alex.
I imagine not, but she's lovely if she is. Yes, so property, it's all the positives and the negatives then, isn't it? So it could be the house, but if you've got the house, you've got the mortgage potentially on there. And then you have businesses. That's often a source of a lot of problems or confusions as to if you have a business, especially if you own it with a business partner, not your spouse, or you have an interest in a company or a business partnership, how do you carve out the value of those shares? So all of this goes in. And then, of course, personal businesses, if you run a personal services business, you might be a builder, you might be a lawnmower, you could be a lawyer. It's only really worth anything when you're doing something in it. So working out values of those things can sometimes be very complex. But yeah, you're right about the old pen and paper trick, though. There's nothing wrong with that. There's a very helpful form that the courts produce called a balance sheet. And that's a really good starting point. It's just a list of assets, liabilities, superannuation with notes that you can put anything else. And what it does do, it's got your version of the value column and it's got their version of the value column. So you can see at a glance the things that are agreed, the things that aren't agreed. And it's very helpful to start with something like that. That's your property. And we call it a property pool in our universe because, we don't swim enough. And so that's what we go diving through. So let's have a little look. We mentioned, or you mentioned at the outset then, that there's no automatic assumption of 50-50. That's just not how things work in property cases here in Australia.
No.
So if a couple are together, how do they start going through? What's the first thing? Once you've done your property pool list, you've identified what there is, and we can talk about hidden assets and things, and we'll probably do that with another episode. We're just talking today about the process and the principles.
So the next thing that you really want to look at then is how did that property pool come about? And what we're talking about there is we're talking about contributions. So they can be financial contributions or non-financial contributions, including things like homemaking and being a parent, for example. So when we're going through those contributions, what I like to do is I like to set it out who had what at the start. That gives you some kind of indication of those initial contributions, what happened throughout the relationship, and then what's been happening since the separation.
Gotcha.
And that's when we tally up all those contributions. Unfortunately, there's no mathematical exercise. You don't get a score out of 10. You don't say, oh, well, I'm a financial planner and therefore I get extra points because not only did I bring in income, but I also, because I'm a financial planner, it meant that the decisions that we made throughout the family life were good decisions and therefore I get extra points for that. It's not a clear system. The courts have discretion as to how much weight is going to be given to each of the things that you say that you've done and your spouse have done.
And as you mentioned quite rightly, it's a discretionary power that a judge has got under the Family Law Act. And no two judges are likely to decide things exactly the same way. So one judge may think, I'm going to put more value on the husband's post-separation contributions. And another judge may say, I'm not very interested in that. I'm going to look at it slightly more holistically and focus more upon some of the wife's homemaking contributions. Neither of them are wrong. They're just slightly different, nuanced approaches that they reach decisions on, having heard all of the evidence of the case. Hopefully, if you're watching this and you're going to go through a property settlement, you won't step inside a courtroom. Or if you do, it'll just be for the preliminary sort of hustings, if you like, and you'll sort this out before it ends up in a trial, because trials get to be expensive and very emotionally straining. So there was one thing I was going to talk about on the description of property, and when we're talking about things like wills and maybe your future entitlement, those can be treated very differently according to every circumstance. So there's plenty of cases that talk about if you have an expectation under a will, but it's something that can be changed. We're not going to be utterly disregarding of that if it's a vast amount, but frankly, the testator or the testatrix, the person that might be leaving you money, they can change their mind at any given moment. But
I'd say that's not property.
It's not property. It only has some nature of a financial resource, I would say, or I would argue that it could be, if the person who's made that will has lost capacity in some way. So if you have an aged parent that's leaving you all of their property and it's quite valuable and they have lost capacity, then potentially that could be treated as future contingent property or a future financial resource. You don't know. And again,
I always think it's better to list it as a financial resource because when we talk about the next step in this process, the impact and importance of financial resources will become really apparent for you. Because
I just wanted to mention it because sometimes people, we're of those sort of generations where people are having elderly parents and that they may be looking at their future inheritances and they don't form part of a property pool as of right automatically. Please get specific tailored advice in case your circumstances are different like that. The other thing I was going to talk about with the contributions that you've mentioned is the duration of the relationship can be really relevant. So if you're only together with somebody for 2 or 3 years or 5 years or under, then that's going to be thought of as being a short relationship. And there'd be a temptation for the law to say, well, we might just put you back in the positions that you were when you started and make some adjustment for things that you've done. Not in all cases, of course, because if people get together, buy houses in joint names, embark upon financial ventures and misadventures, have children, even in a short relationship, that's going to mean there needs to be some kind of adjustments done. But I think the duration of a relationship is super important to take into account as well.
In terms of the next step in the process, we move then to, as Alex mentioned, your future needs.
We're already up to step 3, by the way.
We are.
We've done property is 1, contributions is 2.
Yep, 3 is future needs. Now, future needs, they'll include things like age, health, earning capacity. That's the biggest thing, is the capacity. It's not your actual income. So don't think that you can stop earning good money while you're going through a separation because you think it's going to work out in your favor. We look at the capacity to earn an income, not what you actually earn at this point. So,
It's a really esoteric thing, but it's very important to note. So, any brain surgeons watching this, well, they wouldn't be watching this; they'd be watching podcasts for brain surgeons, I should think. But by abandoning your scalpel for a year or two whilst you go through a divorce doesn't necessarily mean that you're not able to earn very large amounts of money by practicing your profession.
and so this is where we also look at those financial resources that we're talking about. For example, you may be a beneficiary of a trust. It may not, in fact, form part of the property pool, but what it may do is say you're going to have entitlement to all this income, all this money over the next however many years, and therefore it's a financial resource that's available to you. And that is taken into account in that future needs section.
Yeah. Although trusts are, they're famously problematic in family law contexts.
Yeah, they are.
Even a very eminent professor who wrote some fairly weighty tomes on the law of equity in Australia found himself caught up in a High Court case that basically deconstructed family trusts that had been set up to protect assets, and those assets got dragged into the property pool. So don't make assumptions about things held in trust. The control and the power of a trust is very important. If you are the trustee and the beneficiary, the court might very well think, well, you can control everything that goes on. We're going to drag that in.
Totally.
Conversely, if you are just a beneficiary and it's genuinely administered that you don't have in a way that you don't have a control of, then it's very hard for a court and therefore your ex-partner to be able to say, that's their property, I'm entitled to some of
Right.
that, because it's not your property as a matter of law.
And that's right. The type of situation that Alex is describing there is, say, for example, there's a discretionary trust and the trustee might be someone that is not very close to you, and you have absolutely no control over when discretionary payments will be made or how they're going to be made or how much. So the court is unlikely to ever, in my opinion, say that forms part of the property pool because
No.
there is no certainty about any of it. And so I always like to look at it and go, is there some degree of certainty that you can attribute to this item that you're not sure if it's property, is it a financial resource, or is it a matter that you need to consider for future needs?
You mentioned financial resources. It's easy to run arguments that somebody has the benefit of regular payments from a discretionary trust when you can point to a pattern of them having received those payments, for example, and
Yep.
when the assets of the trust are discernible, and if you're a named party to the beneficiaries. So I've seen this in a testamentary trust capacity.
Yeah.
Sometimes a parent might try to protect their child from, it might be to try and protect them from a divorce outcome, or it might be because maybe that child
Seen that a
has
few times.
yeah, that's right. It doesn't always work, but it can work. It may be that child has got history of making bad financial or personal decisions. They're too much on the drink, or they've got involved in drugs or gambling or something like that, and so they try and lock away that money into a safe testamentary trust. That is not likely to be property still because it's never vested in them for that very purpose. But it could well be a financial resource that you argue, and a court wouldn't ignore its existence. It would be,
No.
I don't want to spoil the fourth part of this, but when we get to it, but it might
Yeah.
offend the fourth limb.
But before we do get to that fourth limb, there is a big change that has been made to the Family Law Act, and we're dealing with the importance of family violence in property matters. Now, there was case law about that previously, but it was never embedded into the legislation as it is now. And in a lot of instances, people would focus on the family violence as being a parenting issue, not so much a property issue. And what happens now is that if it's the case that you've been subject to family violence, there's a two-pronged aspect that gets incorporated into a family law matter. And the first is in relation to the contributions that are made. So sometimes the family violence might be occurring, it makes your contributions even harder to make them. Let's look at a really obvious example. Husband beats up wife, she's physically incapacitated, cannot go to work. This is a very obvious example. Her ability to make those financial contributions are restricted due to the family violence.
Yeah.
And the other prong in relation to future needs is that it may have impacted the way that you can cope, or that you may have developed some psychological illness which may impact you. It may be that because you haven't been in the workforce, because you've been subject to emotional abuse, you then go and separate, and then you try and find a job and you're seriously disadvantaged, your earning capacity is reduced, and it's as a result of that emotional abuse. Okay. So there's two ways that we look at it, and that's all now incorporated into the Act.
So we're no longer reliant upon case law. It's now built within the Family Law Act. That's a proper consideration in every property settlement matter now.
That's
so the
right.
judges deciding a property case, it will be one of the things they'll go through and go, well, has that arisen in this case?
I think it's also important at this point to say that it's not designed to punish. It's not like compensation. You might think, I've been subject to coercive control for the last 20 years of the relationship, or emotional abuse or financial abuse. But if it hasn't had any effect, whether through contributions or in terms of your future needs, then it's unlikely to be a situation that you're going to need to bring up as part of the property settlement.
Yeah. It's a very specific set of circumstances that it affects, but still, It's there. It's now being codified. It's in the legislation, so it's less of an argument and more of a process now to make sure that's considered. And so, what other things are we going to be looking at with future needs? You've got somebody's age, so how old somebody is,
and how many years they've got left of their
effective working life. Yeah.
Particularly when you have the fellow who is nearing retirement, earns the income, nearing the retirement age, but you've got the younger wife who earns less, but she's got more years. Always an interesting little dynamic, that one, as to how we approach future needs on that.
Trying to balance those two things out. And if somebody hasn't really been in the workforce for quite a long time, but they've still got a long time ahead of them and could retrain. But certainly the May to September relationships have a different dynamic to them. You know, if there's an age gap between the partners and one of them's not far off retirement and one isn't, that can have quite some context. Yeah.
And I think the best thing there is that you've got to get your advice, because it's definitely going to be something that might upset everyone. And you're going to have a range of differing opinions. You're going to speak to a lawyer, they'll tell you one thing. You'll go to a next lawyer, they'll tell you a different thing. But when we're talking about these processes and steps, we are only ever going to be talking in ranges. So that's why you might hear us say, well, we think that the range is between 50 to 60% in your favour. Anyone that comes up to you and says, oh yeah, you're going to get 73% exact, like, you know, no, they don't know that. That's just nonsense.
So age is relevant.
Yeah.
And obviously health is the next thing I'm going to think about.
Yeah.
If you're both in good health with no underlying conditions, great, that kind of equals each other out. But if one of you has got some kind of a medical issue that is going to recur, I'm not talking about, you know, you've got a cold on the day of the trial. Sorry, bad luck, buy a box of tissues. But if you've got something that's going to recur and genuinely impact you and how you live and what your needs are, that's going to probably cause an adjustment to be made in your favour.
Or it could go the other way. Because if you've got a terminal illness or something
I've had that situation as well.
Yeah. If a party does die, there goes your future needs. So if you've got a very short life expectancy, there's no point, in my opinion, running any future needs argument.
If you've got a short life expectancy, then don't get yourself embroiled in a long litigation.
No, that's just right. Do something else.
Go and sit on the
holiday.
beach.
Go on a cruise.
Do something.
Yep. Okay, cool. So the last part is
What about children?
Step. Yes. Forgot about the kids.
Children. Yeah, that's right. Where are they? Yeah.
Where are they today?
If you've got the care of the children of the relationship, or in fact any other financial dependent, you know, maybe an aged relative who you both know as you've gone through a relationship you are caring for, or somebody akin to that, predominantly children, but they have to be factored into what you're going to get, because it will impact upon your ability to earn again. It all comes back to this: what are you going to get? What are your needs going to be into the future, and how will they be impacted by, you know, the life that you're living? Looking after children has a big impact upon people's ability to work and do things that generate income. So that has to be factored in.
Yeah, but on that point with children, just be careful. Sometimes you'll see the parent who all of a sudden is interested in the kids when it comes to property. And then magically enough, the property settles and then there's no more interest in that push for a 50-50 time.
It's kind of brutal, isn't it? But that's true. I mean, it shouldn't happen, and I'd never advocate any of my clients ever do this. But I've seen it happen too many times, that children are used as a form of bargaining chip in a way in these property settlement matters. That ought not to be the case. If you've got a practitioner that wants to do that, then you probably need a different lawyer.
Totally.
On that lovely note, let's move to the fourth and the most amorphous kind of limb of this four-stage property settlement conversation. What is it?
It's whether it's just and equitable, or as my UK friend calls it, equitable. So what you call it? You call it equitable?
Equitable, yes.
Yeah.
What do you call it?
Equitable. Yeah.
Fair enough.
Australian, UK. There we are. Difference.
Well, I'm an Australian, I'll have you know.
I know, but as in the accent.
Oh, yeah. Well,
Yeah.
I came out of England a little while ago, but still English.
We can still tell.
Can you? I thought I'd hidden it right now. Mate.
So just and equitable. So
Justice and equity, yeah. I mean, that goes...
That's
It's
a
the
tricky-
language of the Family Law Act, isn't it? It's justice and equity.
look, the funny thing about all this is that the court, they'll only make an order in relation to property adjustments and things like that if the orders are in fact just and equitable. When we're talking about that, trying to explain that to the client, a lot of people try and use the word fair, but it's not necessarily fair, because fair is a very relative term. You may not think it's fair that you've done all the work and that she then walks away with 65% of the property pool. You might think that's not fair, and therefore that's not justice and equity. So when we're talking about justice and equity, what we're looking at are things in terms of the implementation and how these orders are coming about. And is it the case that are these orders simply just aspirational, or is this within the range?
It's probably the most difficult one, because it very much takes into account the specific circumstances. So if you have a friend who has a particular outcome and they say, oh, you should be getting 60% or you should be getting 70%, remember that they've got a very different life to you, and very different background, different antecedents, different financial setup. You just don't know. It's very nuanced, it's very tailored and very personal. And at the end of the day, if you are misfortunate enough to find yourself in a litigation where a judge is deciding, then what is justice and equity? Well, there's an old-fashioned saying in English law that justice is as long as the Lord Chancellor's foot, which basically means it's in the purview of one individual, the judge, to decide what is just and equitable in your case. That's not to say you have appeals, of course, and they have to follow laws and they have to follow what's in the legislation, what are in the precedents, but it's precedents to you, I believe. But it's a case of knowing that there will be a range. We've talked about ranges. And it could be a shift of between 5 and 10%, which could be a lot of money, depending upon Judge A and Judge B, which is why you'll probably find any lawyer worth their salt really trying to work through anticipating the issues that could arise so that they can give you advice about, look, this is your range. To get to somewhere like this, it's going to cost you X dollars. Therefore, try and settle it around this point and save yourself a year or more, and goodness knows how much money in expensive counsel's fees and so on.
I did receive a question this week. I think it must have been through socials. It's not advice. There is that disclaimer there. So, short relationship, unequal starting wealth. Where do we start?
Well, I'd start with the balance sheet.
I think you kind of touched on this before, Alex, but I just thought I'd just raise this.
You've got to know what it is that you're actually talking about. What assets? Do we have debts? Make a list. That's the easiest thing to do, is to get a grasp on what there is to be dealt with, because it may be more, it may be less than you expect.
Yep.
And
then what would you do next? Let's just say, for argument's sake, you're sitting down with your partner or ex-partner. Would you then go through what you've both done, almost like a joint set of facts, or would you just jump ahead and go straight to, this is what I think the pool is, and then see
I'm
what...
going to go back more years in my mind that I care to admit, when I did have a short relationship that didn't work out. And what I did was to run away broadly and say, you can keep just about everything because I need to get on with my life and I don't want to be in this relationship anymore. I'll start again. So it's not great legal advice, but it's what I chose to do at that time.
Do you know what, though? It's actually perfectly reasonable and understandable. No one's going to judge you for saying, look, let bygones be bygones, let's just move forward. The other thing I wanted to just reality check people was that in the eyes of the court is anything under about 500,000.
Is it the 500 triple P
Totally.
program, isn't it? Anything that I discern that's got a net property pool of under 500,000, they'll try and fast track you so that you can get out of the process sooner. Honestly, try and fast track you. And we won't be having any kind of a pop at the courts because they're doing their level best to try and get people through this. And It's a very complex process. And it's caught up with all the emotion of the breakup too. But so pathways and exact processes, we'll definitely touch on that in a separate episode. We're out of time, I think. So again, just information.
Yeah.
But if you've got any questions and you want to get in touch and see whether we can help you with your case, then please reach out to us through the socials, through the podcast. And thanks very much for listening.
Thank you very much. See you next time.